Hello, everybody, and welcome to History/Law Bite number 178, dated February 7th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Smith versus Allwright, 321 U.S. 649, 1944. Smith versus Allwright was a very important voting rights case decided during World War II with respect to the subject of white primaries. Yes, white primaries. So allow me to give some context first. As you all probably are already quite familiar with, in the first half of the 20th century, the Democratic Party essentially reigned supreme in the southern states, okay? Republican Party did exist there, but it was very weak and inconsequential in most elections, okay? It wasn't a real challenge to the Democratic Party in the South, all right? So essentially, the Democratic Party was the party that prevailed about 99.9% of the time in most southern jurisdictions. And as such, most general elections were decided by whoever won the Democratic primary. And as you know, it's like that in many jurisdictions in America today, party notwithstanding. Certain Democratic jurisdictions like Baltimore are a prime example. Our elections, at least for most city offices, are almost guaranteed to go to the winner in the Democratic primary. All right, we have Republican contenders, but it's more or less just for show. And of course, the general election in primary jurisdictions is a formality. Okay, the winner of the Democratic primary is almost guaranteed to win. So the general election really is not that important, which brings us to what's going on here in Smith versus Allwright. So in Smith versus Allwright, we see the issue in the state of Texas, okay? In Texas, like most southern states, like I said, the Democratic Party reigned supreme. And Texas adopted a law in 1923 which had allowed the Democratic Party to control the internal particulars regarding membership and other things, okay? One specific provision in the Democratic Party's requirements, at least in Texas, was its prohibition on African Americans voting in Democratic primaries, okay? And thereby closing out any real ability of African Americans to affect the electoral outcome. Okay, African Americans could, of course, vote in the Republican primaries, but remember, and of course in the general election. But if they couldn't vote in the election that mattered the most, the primary, what did the general election really matter? Remember, the Republicans are not competitive in the South at this point in American history. So, in this case, we see Mr. Lonnie Smith, who is an African-American man, a dentist by trade, living in the Houston area, who filed suit against a local election official named Allwright, okay, for the ability to participate in the local primary election, all right, in the Houston area, all right. And Mr. Smith asserted that his 14th and 15th Amendment rights were being denied, as he was being denied equal protection of the laws as required by the 14th Amendment, by not being allowed to participate in the only meaningful election in his jurisdiction, the primary. And his 15th Amendment right was being violated as he was being denied the ability to vote based exclusively upon his race. Mr. Smith failed in the U.S. District Court, and he also failed on appeal in the U.S. Court of Appeals for the Fifth Circuit. So the matter was taken to the Supreme Court of the United States. And, the justices were presented with the issue of whether or not state laws directly allowing white primaries were unconstitutional. Okay? The state itself, on the side of the petitioner, rather, let's start there, of course. The petitioner, Mr. Smith, of course, asserted that, yes, they were unconstitutional, as the state permittance of white primaries directly ran in contrast to the 14th and 15th Amendments to the Constitution, okay? Keeping blacks in a state of inequality and denying them their right to vote, all right? The respondents in this case, Mr. Allwright, argued that the Democratic Party, as a quote-unquote private entity, had the right, under the laws of the state of Texas, to set its own qualifications without interference from the state or the federal Constitution at all. All right, this was a private matter. All right, and as Texas had allowed them to govern their own particulars, they didn't really see what the big issue was. All right, it's not. The blacks could still vote, okay, in the general election. All right, if they dared try to do so, depending on where they were in Texas. All right, officially on paper, the ability was maintained to an extent, but in practice, it was a different story. All right. So the Supreme Court of the United States, to the surprise of many, in an 8-1 decision, ruled that Texas's white primaries were unconstitutional. All right. The court reasoned, quite simply, that because the state of Texas had delegated its authority to the Democratic Party to regulate its internals, okay, and thus primaries and membership, to a significant extent, this deregulation and endorsement of white primaries constituted a form of state action, and therefore the state of Texas was in clear violation of the 14th Amendment's Equal Protection Clause in sanctioning white-only primaries, okay, and was in clear violation of the 15th Amendment to the Constitution, because these white primaries effectively disenfranchised all African Americans from participating because they were African American. 15th Amendment does not allow the use of race as a qualification for voting, as we know. Okay? So, with that being said, it was unconstitutional thus for a state to delegate its authority to a local political party so that racial discrimination could carry the day. That was clearly prohibited by the 14th Amendment to the Constitution. And so white primaries were therefore ruled unconstitutional. Okay? States are not allowed to sanction primaries that are race-based. Okay? And that's exactly, obviously, what a white primary was. Okay? Primaries, under the court's decision here, had to be open to members of all races to be in compliance with the 14th and 15th Amendments to the United States Constitution. All right. So the essential bottom line holding of the court in this decision was that white primaries are unconstitutional. All right. The state cannot support or sanction any type of primary elections that are race-based. All right. Okay. Even if they themselves directly are not the ones doing it, even by delegating it to a local party, that's still state action that they're endorsing. And thus that is prohibited by the 14th and 15th Amendments to the Constitution of the United States. Okay? There was one dissent from this case, written by Justice Owen Roberts. Justice Roberts was a little salty here because the court, entirely overruled his decision from 10 years earlier in Grovey versus Townsend in 1935. And he chastised the majority here for throwing out what he perceived as very good logic, and even made a very famous statement from this case that the Supreme Court's decisions are like train tickets. good for one day only. Yeah, he was a little salty. Thurgood Marshall, who, of course, we all know about Thurgood, who would later become the court's first African-American justice, he argued this case before the court in 1944 and would later say that this was the most important case he had ever argued before the Supreme Court of the United States. All right. Mr. Marshall argued more than 30 cases before the Supreme Court of the United States over the course of some 3 decades. And this was the one, not even Brown versus Board of Education. This was the one that he said was his most important. Okay, so the immediate effect of Smith versus Allwright was to substantially increase the amount of registered black voters in the South. All right, and that effect was felt very quickly in virtually all subsequent state and federal elections. Okay, forgot to mention the majority opinion here was written by Justice Stanley Reed. Okay, so that is Smith versus Allwright, folks, a very important voting rights case that declared white primaries, something that was very commonly in use at the time in the South, to be unconstitutional. All right. So if you have any questions or controversies, just leave them down below and I'll be happy to answer them. If you have not subscribed to my YouTube channel, please just hit that little red subscribe button and that little bell and we will be in business. I appreciate you for listening to the video. Appreciate you more than you will ever know. Okay. Take care. Stay safe out there and I'll talk to you at the next bite. Peace.